Right, hello. Sorry, we're a bit late starting tonight. It's Tuesday instead of Monday as well, so it's very late compared to normal. And it's is it the 13th of May today? Um, and it's hopefully going to be a slightly more structured session because I've got a list of things to talk about, and I've hopefully got my screen so I can show things. But sadly, before I go on, Shannon can't be with us today, but hopefully we'll all be back on Thursday. Yeah. Um, so what I will do is move on to this screen here, which, if I go back to my blog, so you can find the list of things we're going to talk about today. If you go to William Flack blog, and you'll get this list. And I thought it's useful to, it's useful to have some materials so we can refer back to them. Um, so this is the first time I've done this, so forgive me if it seems a bit random, but I'll just talk through the things on the list here. So I won't necessarily do it in order either, if that's okay. I'm going to start off with a law report, which I think we talked about last Thursday briefly, or even, yeah, I think that was the last time we were talking. And it's this case of it's called Ayinde versus Haringey. Um, what I'll do is I'll open up hopefully this will work. If I go to the full judgment, I'm not going to read it all out, but if I just summarize what happened in this case, um, there's a good summary on the Nearly Legal page. It's a weird case because just about everything went wrong in the sense that the council, I mean, I'm not even sure what the case was about to start with. I think it was about vulnerability or suitability.
Yeah, it was
And
vulnerability, and it was pretty good evidence already.
yeah, it seemed like Mr. Ayinde had a good case. But the problem was, and it was made stronger by the fact that Haringey failed to put in what's called a detailed grounds of resistance, which is a judicial review term for a defence. And so they didn't defend the case, and they applied for what's called relief from sanction. And that's where, I mean, if you don't put in a defence, you're not allowed to carry on and defend the case. So you turn up at trial, and the judge says, "Well, I'm not going to listen to you because you haven't put in a defence." And so you apply to get over that and for relief from sanction, but you have to put up some good reason. But I think the judge summarised it here as being the reason that the person from Haringey gave was it was the person before me that was responsible for this, full stop, and that wasn't good enough. Um, so Haringey were having a bad day, and Mr. Ayinde's lawyers were entitled to be pleased about things. But then Haringey's lawyer pointed out that there was this problem with cases that were quoted in the skeleton argument by Mr. Ayinde's lawyer didn't exist. They were sort of fake cases, and they also pointed out they'd drawn this to the attention of Mr. Ayinde's lawyer solicitors, who had given rather a sniffy response to the effect that it was only a cosmetic mistake and it could always be put right. And the judge wasn't happy with that either. I'm not going to go too much into the solicitor and barrister conduct because, as a lawyer, I mean, it would be on one level, it's fun to see people sort of slip on a banana skin and do a somersault and stuff. But there, but for the grace of God goes me. So if you want to read it, go to the judgment. But what went wrong was that it looks like what the barrister did, and we don't know how these fake cases got into the system, but I think they were using artificial intelligence. So she probably asked it something like, please give me some cases or prepare a skeleton argument for me based on this. And they came up with authorities. And artificial intelligence has a flaw in it, which is known as hallucinating, so that it'll sort of make things up, and it thinks it can see things which it can't. And that's what happened here. And
I think, well, I think the judgment was agnostic about whether AI was used, and I felt
No,
like they
it
were
was.
deliberately agnostic.
You're
So I
right.
think, although I think everyone's probably speculating it is, I think I don't know that that's actually in the judgment.
No, you're right. The judge does expressly say that the barrister wasn't put in the witness box and required to give an explanation of what had happened. It was the claimant's, Haringey's lawyer, who suggested this as a possible explanation. And all I can, I mean, all I think I'm allowed to say is that that sounds like a good explanation to me, because I can't think why a barrister would deliberately make up false citations knowing that they couldn't put a law report. Because when you go to court and you refer to a judgment in the case, you have to come to court with a copy of the law reports at the trial. So you're setting yourself up to look stupid if you put false ones in there. You'd either have to create a false law report, which is pretty hard work, or you'd have to admit that you'd got it wrong. So they got into trouble there. Now, where are the moral for any lawyers watching this is, and it's so true, is it, as a lawyer, you're often go into sort of confrontational mode, and then you stick in that mode and you can't get out of it. So that if the other side suggests to you that Tuesday comes after Monday, you'd sort of make some, oh, I couldn't possibly concede that point and I reserve the right to blah, blah, blah. And if you make a mistake and somebody points it out, it's sort of either it's outrageous that they could suggest that, or B, the mistake is only minor. And it's best to just put your cards on the table if you make a mistake and say it and apologize. Because you only dig yourself deeper into the hole. But the point is, at the end of this case, the judge says that he's producing this judgment, and then he's going to report the case. No, he's expecting the two lawyers to report themselves to their professional bodies, and that's quite a serious problem because it does involve the allegations of dishonesty, not necessarily on the solicitor, but definitely on the barrister, because the barrister gave an explanation which is hard to think was a true one. Now, I'll move on from that actual case and I'll explain, sorry,
Can I just
why.
ask a question, Will?
Yeah, of course.
So obviously there are barristers who specialise just in homelessness,
Yeah.
but presumably there are barristers who basically cover all sorts of things. I guess I'm just interested to see why a barrister, let's say it was ChatGPT or something. So they asked ChatGPT to do a skeleton argument. Would the barrister know homelessness law well enough to know that they weren't real cases, or did they likely just not check it, or how does that kind of thing happen?
Yeah, I mean, that's a good question because I checked the website for the barrister who we're talking about, and their profile said that they specialized, they had lots of experience of this sort of thing. And I suppose it's one of those sort of dilemmas of any job thing, that you don't get work until you've got experience, and you don't get experience until you've got work. And another problem is that barristers' clerks will tend to talk them up rather than talk them down, and so will websites. So I think that the barrister probably, given the benefit that they knew what they were doing, but in terms of they know about housing law, but maybe they just thought they'd add some extra cases in. I don't quite understand it. What? Sorry, Karis.
Sorry, I'm just interrupting. How real do they have to make the AI make the case look though?
Well, they did quite a
Does it
good
go into
job.
whole detail of this case is this and facts statement and judge it, not just a citation?
Well, according to the judgment here, the not only was there a sort of wrong description of the case, sort of blogs v blogs, or the London Borough blogs or whatever, which didn't exist, but then it also said what the case was authority for.
Yeah.
So, and that made sense. I mean, and the judge made the point that the things that the cases were quoted as authority for were actually good points, but unfortunately they hadn't been made. So I think the problem you've got is that barristers maybe want to get, when I first started doing housing law, I didn't know, obviously by definition, I didn't know anything about housing law. And I went to court and I did a couple of things which I get a cold shiver down my spine when I go past the court. There was one time I went and asked for a possession order, and the grounds I gave in the particular claim was that the tenant had said he was going to leave at the end of the tenancy. And the judge sort of said to me, "Is that what you're basing this on? Don't you know about notice of seeking possession and statutory grounds?" And I said, "No." But he said he was going to go, and I had to sort of he dismissed the case obviously and said that's a load of rubbish, and then I had to turn around and see my client, the sort of shocked looks on my clients' faces as I walked out of the court. But I learned a valuable lesson that day, and I then relied on statutory grounds for possession, and I was aware of them. So everybody has to go through that stage, and I wish I should say, my heart goes out to the two lawyers involved, because although it's easy to paint them as sort of baddies in this picture, they're human beings and they're trying to do a reasonable job, and I hope everything works out for them. So if I could move on, and this is where I think it worries me what might happen if they get referred. And I thought I'd just mention this story here. This was in the Law Society Gazette, and it's a couple of weeks old. No, it's 30th of April, and it's a very sad story. And again, it's a bit mysterious. A direct access barrister, which is something I wouldn't recommend barristers to do unless they're really confident, because it means you take instructions directly from the public without a solicitor. And that means you're exposed to the nasty stuff from a lay client, which you probably wouldn't get from a solicitor. And in this case, the barrister gave the person a negative opinion and said, "Sorry, you haven't got a case." And it looks like they had a conference at the chambers, and as clients often do when they're not happy with the advice they get, their immediate response is, "Right, I want all my papers back." And so I think the idea was the barrister was supposed to go and get the papers, and these would be the original documents, and then give them to the client. But the barrister wasn't sure where they were in chambers, and he told a little lie. I say a little lie because it's not really that big a deal. He said, "Oh, maybe I left them at home. I'll check and I'll get back to you." Somehow it came to light that the barrister knew they weren't at home, and the client found this out, and that meant that the suggestion, "Oh, they might be at home," was dishonest, because he knew that they couldn't be at home. And the client reported him to the bar standards people, and he got fined no less than £100,000 for that. Which you think in other walks of life, you've got to do something pretty damn serious to get a fine, rather than just say, "I think I left some papers at home, I'll go and check them." The good news, when I use that term so loosely, is that the story is he did appeal it, and it was found that the £100,000 was disproportionate, and he got it down to £25,000, which I still think is a horribly high fine. But it begs the question, which comes up quite a lot, of what is honesty and dishonesty in the legal world, because I think most members of the public think all lawyers are lying all the time, and I think they're right in the sense that you see lawyers arguing their client's case, which doesn't make any sense, and it's obvious that to most people the client's lying, but the lawyer seems to buy into it, particularly in America, where lawyers seem to appear on the news sort of saying, "My client could never have done this," even though he had a gun in his hand and he was outside the house where the person got shot. He was just passing by on the way to gun practice or something. But the point here is that the legal profession take it so seriously, and I'm not saying that sort of deriding that, but I think there has to be limits. I mean, if we all tell lies, I mean, if if a child asks you a question about whether their terminally ill parent is, you're not going to say, "Yeah, they're going to die in a month." You say, "Well, let's hope that everything's all right." And you are being a bit dishonest because you know the answer, but it's an appropriate lie. And some of these lies, I mean, I think if somebody actually tries to mislead somebody, they take money from a client and then lie about it, or they base the whole case on false evidence. That's pretty serious. But I feel very sorry for this person here that's got to pay 25 grand. I don't know. What do you guys think?
There's a very interesting guy called Dan Ariely who I used to really like. He's a cognitive, I don't know what he's kind of psychologist type person, I guess. Was in MIT, kind of top universities, and he's done a lot of research and books about dishonesty. And he was later found to have falsified one of his big experiments. So he's I mean, we're not quite sure how much of his other research was legit, but he did a lot of stuff on. Essentially, his message was it's not just a couple of bad apples, like the whole kind of you have entire teams affected by dishonesty a little bit. So his kind of message was everyone lies a little bit, as you say, and there's kind of some interesting experiments around that. Things like filling in your insurance claim form and stuff like that, and various things. And so I think within a team you have to have a very strong culture to kind of stop that getting eroded. You have to be really, I think, intentional about maintaining standards. Certainly when I worked in Bedford Borough Council, there was a huge amount of dishonesty, which kind of came from the top, to be honest. And I think that absolutely affected the team. And I think had they had decent kind of team leaders or whatever, then I think the whole team would have kind of acted a lot better than they did. Not to say that everyone was acting dishonestly, but certainly there was some dishonesty for sure. And I think it's just something which in every kind of walk of life you have to be really, really as I say, intentional and conscious of it, and kind of constantly kind of fighting that battle of like, okay, we're gonna kind of make sure we don't kind of slip into these little white lies or whatever. So it's yeah.
But it does seem a bit extreme, doesn't it? Though I mean maybe
25k is that's. I mean, I don't know how much barristers earn, but that seems to be that's like a bit many months worth of salary. I thought.
Yeah. I'll say no more about that other than to wish the barrister well and hope that
Do you think there's more to the story though than what the article says?
Well, probably, yeah, but I can't quite figure out why the client was so well, I can because I've seen it before that if clients will turn on their lawyers with venom that you've never seen, and it seems that there hadn't been a very long relationship here, but the client went to great lengths to pursue the barrister and cause them a lot of misfortune, which I guess is their prerogative, but then it suggests there might be more to it, and that the client felt so strongly about it. And I apologise to the client if the barrister had done all sorts of other things wrong, which justified this somehow. But I guess we only see a little snap. We only see a little bit of the picture here. The problem as well is it just leads to I mean, what worries me here is if this guy got 100 grand for that, what the hell's going to happen to the barrister who gave the false law reports and told the judge that these were real law reports that she kept in a box in the office, which apparently she did. But I would hope that, not a slap on the wrist, but I'd hope that somebody would get a telling off and be allowed to continue to practice. But that could be a career-ending result, and I hope it isn't. And I think we all need to be a little bit compassionate on these things. So I'll come back so the combination of AI brings me on to and dishonesty and stuff and problems brings me on to this story, which is that the launch of what's described as the world's first AI law firm, which sounds like trouble to me, but what they do, to be fair to them, is they do what a lot of lawyers have been trying to do with technology for most of my professional life since the evolution of the merge document. Remember those where you would have a database and it would have a letter say, dear so-and-so, you owe my client £500. If you don't pay by insert date, we will take you to court. And then you had a whole suite of templates that enabled the whole thing to be automated. And it never seems to, I mean, it does work a lot. People do have a lot of merge stuff, but it hasn't revolutionized things. But this one, they'll it seems that they will they will take the whole case on, and it'll all be dealt with by AI. Starting with what's described as a £2 polite chaser letter.
Will,
I,
you're not, so I'm following this
oh,
on the blog,
sorry,
but you're not sharing the
you're right.
screen.
Thank you. I will go back. You should be seeing this, which is the piece from the Gazette. And actually, for some reason, it's just gone a bit to over there.
Would there not be a very high risk here of the same sort of thing in terms of AI hallucinating and potentially?
Yeah.
Presumably, you'd be held to the same standards if you know, whoever the director of the company is, if you've got AI writing, making up, kind of case studies and whatever case law, would that not be would you not be a subject to the same risk?
And would they make up clients? Wouldn't they?
Yeah,
I remember there was there was I can't remember which, I don't know, I think I do know, remember which district it was. There was a drug and alcohol service, like this is going back 10 years, and they were somehow caught making up clients, because you basically get paid by results and kind of how many clients you've got in, so they're just literally making up names, making up outcomes, and they're getting paid on the back of it.
Oh, yeah.
I wonder how often that kind of stuff happens and people don't get caught.
I think it happens a lot, but ultimately, I think the more you do it, the more you get caught. Because we were talking about the mental health firm that was not only inventing clients who they were trying to get out of mental health hospitals, but they were inventing hospitals, which, well, they'd been closed for some time and they were still using them. But you're right. I mean, maybe the problem you've got as a firm is that your AI system may start hallucinating clients and doing loads of work. And writing to people. But the website does have a frequently asked question about hallucination, and the answer is, you would check it if your human lawyer does a letter for you or something, you would always check it. And I thought, well, yes and no. I mean, if a lawyer does a sort of drafts up some 400-page lease for you, you're not going to go through it looking for hallucinations. So I wish Garfield Law, and it makes me think of that cat when I hear that name, but because neither of these gentlemen who have set the firm up are called Garfield, so maybe the cat is an inspiration here for somehow. But I wish them luck with that. But it sounds like problems if you've got clients complaining and you've got to figure out what went wrong, and it turns out there was a hallucination. But I guess it is the future. The AI. I mean, we can't get away from it, and I have been playing with it a bit myself lately, and I found it very impressive that I could upload a law. I mean, where it's useful is not necessarily getting it to sort of run your life for you, but I put in one of these judgments. I put it into ChatGPT, and then I started asking it questions like, "What was the name of the judge?" And it comes up the judge was Mr. So and so, and I thought, wow, that's pretty good. So you could go through a library of documents and say, can you tell me what these cases tell me about the definition of vulnerability, say? So I'm going to look into that more and report back. So those are the stories. Oh yeah, there's another story I should mention, which is that the Housing Law Practitioners Association has made a report to the regulator of social housing concerning Lambeth Council's Lambeth Council being dreadful as a social landlord across the board, and it's quite a long it's quite a long letter. It could probably be a lot longer if they wanted to take the time, but it's 17 pages, including some case studies, and I'm pleased to say, just blowing my own trumpet here, that one of them is from me, I think. Yeah, there it is. William Flack, Morrison Sparrow. And by a strange coincidence, this case that I've complained about here, well, I've given them an example of a bad case. The case is in court tomorrow by strange coincidence, and there's a hearing, and I've been writing to Lambeth solicitors for about 6 months saying, what are you going to do? Are you going to do the repair works? It's a disrepair case. Are you going to do the repair works? When are you going to start? And I get a response saying, we're seeking instructions. And I know the solicitor, he's a really nice guy. And I don't want to be mean to him because I know that he's trying. But we had a hearing date tomorrow for an order that they do the work, and I sent them a draft order saying, here, you can sign this, but 5 to 5 this evening, I got a message back saying I still haven't been able to get instructions. Can we adjourn it? And I said, no, we'll have to go ahead and get an order. But it really is terrible. And that's been going on for 10 years. I'm not the first solicitor to deal with this case. So Lambeth, yeah, you can read about how Lambeth have failed the people of Lambeth in their role there. I would, if it is in Lambeth's favour, I don't know, but I think anybody that hears this will say, well, hang on, it's not just Lambeth. Most of the London boroughs could face this sort of criticism if somebody wanted to, if not completely widespread, but just awful things happening. And in a way, it's like with that video you made, Mike, about the woman who had just detailed her dealings with children's services, and what do you remember the one I'm talking about? And everything that could go wrong did go wrong. Like more than one social worker told her there's nothing we can do other than take your children into care, and awful things. So it just seems to happen across the board. But Lambeth have always probably been out there at the front of the really bad service provision. And so that's the end of that one. Oops, let's go back to the cases now. And so we've done Allende, that's the artificial intelligence one. Can I talk briefly about Mohammed v. Hounslow? This case is, before I go on, I'll just point out to anybody that's watching, what I've done with this, you may see that when I click on that link, it brings up this little summary of the case with tags, which I've created in an application called Notion, which you can see. I won't go into what Notion is, but it enables you to. It's basically started off as a note-taking application, and you can publish the pages as web pages. So this, and you can also create databases of pages, which I've done here. So if you want to, you should be able to access this. If anyone has trouble doing so, please let me know. But I've got loads and loads of law reports in here, and you should be able to search for them by going. And if we take, let's think of one. Let's say Tower Hamlets. There must be a few with that word in there, or those words. So yeah, so you can just click on that, and it'll take you to the notes about the judgment. So that might be useful for people. But going back to this one, this raises an interesting question that people often ask, is that if you go to a homelessness appeal, does the judge make a new decision for the council, or does the judge just say, no, you got it wrong, go back and do it again? And the answer is both. But there will be times, it's more, the default position is the judge will say, no, this decision's unlawful, I'm referring it back to the council for another look at it. And that would be particularly true in things like intentional homelessness or vulnerability cases. But if in other cases, it's possible to persuade a judge that there's no possibility that the council could make a different decision if they were given a chance. So the judge may as well make a finding. And that could be because the council have shown they're incapable of approaching the case properly. Sometimes councils get it in for a particular applicant, and the attitude of the staff is, we will not back down to this. We're going to find against them whatever it takes. So you get 5 different appeals or something. And by the 5th one, the judge says, no, look, you guys, you're never going to find for this guy. I'm just going to make a finding. But with suitability, if they offer something that's really, really bad, and they try to justify it, and the judge is satisfied that it's so bad, there's no way you could spin it so that a person in a wheelchair could be expected to climb 10 flights of stairs with no lift, the judge will say, I'm substituting a decision. And that happened in this case because the appellant's son had very special needs. I mean, it's which required almost constant supervision, and well, probably constant supervision. So my heart goes out to the parents how you cope with that. But it's made worse when you get so little sympathy. But often with local authorities, you get an approach saying, this sometimes happens with people at the beginning. They'll say, your needs are so acute that we can't help you. We only cater for people with less special needs. But here, the argument was they offered some accommodation, but they said basically it's suitable because nothing will ever be suitable for this child because his needs are so great. And literally, the only solution is to supervise him constantly. And they also said that also you could try and get the landlord to make adaptations. And the judge said no, primarily because you can't. This is another interesting point. A council can't speculate that a landlord will do adaptations or make the place suitable. There has to be a sense that the assurance you've got from the landlord to do that is certain, binding, and enforceable, which will be quite rare. And then also, it was interesting here that the judge really focused on the Children Act 2004, the duty to put children's interests first, and also the public sector equality duty, which a lot of people scoff at and say, oh, well, it's just empty gestures. Those are required, but it can make a difference. And also, the council had failed to take into account the views of an occupational therapist. And that led to quite a nice summary of the term irrationality, which I would recommend to anybody to remember, because irrationality in the public law context, also known as perversity, means making a decision that is so unreasonable that it can't be allowed to stand. And sometimes local authorities will respond to accusations of irrationality by saying, that's ridiculous. It's got to be outrageously bad. Or as Council here said, the decision maker must be temporarily unhinged. But that's not the definition of irrationality. It can mean a decision which does not add up, in which there is an error of reasoning which robs the decision of its logic. And that's actually a quote from a case called Parliamentary Commissioner for Admin versus Balchin. But it's good. So you basically a decision which doesn't make sense based on a failure to have regard to relevant information, such as the occupational therapist comments that this property was a danger to the child, or thinking about irrelevant things such as, well, the child may have special needs, but at least he isn't in a coma, which is irrelevant, but often happens in now medical type situations. I say, you may have schizophrenia, but you're not. You haven't been sectioned lately.
There was I was watching the other day the Nicholas Nicol video about now medical, and one of the ones he quotes, I'm pretty sure, says something like whether it was the kind of doctor's assessment, which was, yes, the child might fall, but it's only like 1 or 2 stories, so it's unlikely to be fatal. That sort of thing.
That that one is sort of temporarily unhinged, really, isn't it? I mean, it's so bad. But you get to that, you get this sort of there must be a sort of psychological term for feeling the need to continue arguing something long beyond the point where it was sustainable. And I mean, I've got lots of cases where councils do that. So that's the case of Mohammed v Hounslow. So it's reassuring to see a court finding that a property was unsuitable. And that brings us on to a less encouraging decision for housing lawyers on the tenant side, but something reassuring for local authorities, which is this case of Beach v South Hams District Council. And there's a good article on it there's a good summary of it by Catherine Rowlands, who's the barrister who acted for the local authority. And I must say, although Cornerstone Chambers tend to mainly act for local authorities and are very tough opponents, they do I mean, their website is an excellent resource, and they really do very good law reporting. And she's done a very good summary here. But Mike, would you like to talk about this one because you studied it a bit more than me? I haven't. I started reading the judgment before we today this evening, but I didn't have time to finish it. So what I could do is click on there. So we've got. I won't. But
Yeah.
I'll hand over to you on that.
Yeah, I mean, so it caught my eye because the headline or the kind of something that came up, I think, in the summary was that local authorities can use temporary accommodation indefinitely as a discharge of Section 193, which I don't think is actually an accurate read of the case. So basically, the situation was that family of 8, divorced or kind of estranged parents, 6 kids, and the kind of the on-off relationship between the parents. And it seems like there's kind of hints of the fact that the dad maybe had some alcohol issues, and there's a couple of run-ins with the police, but it was kind of very vague. And it was basically found that 3 of the kids, it was reasonable for them to live with the dad, so he was in priority need for that reason. So main duty was accepted. I think he turned down interim accommodation or temporary accommodation at some point because he was going to try and make another go of it with the wife, but that kind of didn't work out, and so he turned down some more accommodation somewhere along the line. But basically, at some point, he ended up resorting to sleeping in a shipping container with 2 of his kids, I think. Police found out about it, obviously social services involved, and the social worker basically said it's reasonable, or it's basically in the child's best interest right now to live with the mum in the short term whilst kind of the other things get sorted out. And so at this point in time, although the main duty had been accepted to the dad with 2 or 3 of the kids, I think it was 3 at this point, they were all living with the mum. And so South Hams Council, which I think is down in Devon, basically said, okay, well, we're gonna basically provide a hotel room for you as a single person right now, with the view to kind of find accommodation that's going to be suitable for the whole, for your whole family down the line. And he rejected it. There was a bit of kind of, the usual sort of, kind of messiness about it. He kind of saying that he needed a place for a dog and that sort of thing. There wasn't kind of any sign of that beforehand. But basically, South Hams won the case in the sense that, and I think Toby Van Hagen, I don't know how you say his name, but
That's how you
he was
say
kind
it.
of, yeah, so he was arguing for Mr. Beach, and he was basically saying, look, there's nothing within the Housing Act which allows a local authority to walk back on a main duty. If the main duty is owed to the dad and the 3 kids, then the accommodation they have to provide has to be for that whole household, and that's the point that I think, well, that is the point that was lost. And effectively the judge said no, in a situation like this, which is very unique, where the social worker said for the time being the kids need to stay with the mum for that short period of time, it was a suitable discharge, or it was suitable accommodation they've been discharged into, or the dad had been discharged into. He then rejected it, I think, and he was found intentionally homeless from it. So
Yeah.
effectively, it was found to be very kind of there was basically 2 explanations in the case. So there was the first judge and then the second judge. I thought the second judge's explanation was much better than the first, as in it kind of made sense. So I think it was Nuji, or I can't remember the second judge's name.
Let's go back. Yeah.
Because judges seem to do this sometimes, where the first judge will, I guess the lead judge will give an explanation, and the other judge basically said, I agree with the conclusion, but I don't agree with your reasoning. So he then gave separate reasoning, which I thought actually made much more sense, because his kind of thing was, at the point in time that we were talking about, as in like a couple of dates in, I think it was April that year, the kids were not normally resident with the dad because of the social worker intervention, and so effectively the council didn't need to provide accommodation for that whole family, or half of the family unit. So that's kind of that. As I say, I don't think it was. I don't know if they just over-egg everything. I mean, I was nitpicking anyway, because you get people on LinkedIn kind of going in and saying, "Oh, I love this so much," and I'm like, "This is nothing to love. There's nothing to celebrate here. This is a family that's fallen apart. There's nothing good that's come out of this, really." And it's such a kind of niche position, as in every other situation, the council would not be able to kind of get away with it. But because there was this kind of temporary change in the household makeup, that's why they could do it. So I can't imagine it's kind of helping that many local authorities out. Maybe there'll be kind of wider significance. I mean, I thought there's some interesting stuff around the whole wording of normally resident, because actually, essentially, although it was only for a few days, the judge was saying, yeah, well, at this point in time, the kids are normally resident with their mum, so the LA doesn't have to provide accommodations for those people. And I just wonder whether actually that opens up potential arguments around understanding of normal resident when it comes to things like local connection. Like when you've got rough sleeper, they've got no settled accommodation anywhere else. They turn up in a town and they've been there for a few days. Well, who's to say they're not normally resident there? I think there's that kind of potentially there might be some uses of it like that. I don't know. So I don't know. I think that was my kind of thing. But I read it at first. As I say, I don't know if I just misread it or just the way the kind of the Cornerstone portrayed it as like this kind of really kind of important victory, and I just kind of it just something irked me, and it wasn't just me because I know some other people went on LinkedIn and kind of said actually this isn't a happy ending here. So yeah, that was the kind of thing on it. That's my sort of take on it really.
Yeah.
And
Sorry,
yeah,
Karis,
sorry.
please.
I would agree with the lack of insight into the children. They kind of make assumptions where the children are concerned. If normally they do reside with their mother, but there's no provision made for if the children do want to live with their father, and any reports supporting the fact they might want to live with their father, any consideration of abuse of the children, the trauma on the children, from the breakup of the family and the breakup of the home, and the fact that those two children were living with him in the shipping container. Where was that brought up? And that should have been prevented rather than it happening. So my thing with it is like children's services should have involved more, the children should have had more of a say, in consideration for the children should have been, I think, in there.
Sure.
In terms of the limb.
Yeah, I think there was like the sense I got from it was effectively the dad was kind of written off as being unreasonable and badly behaved and whatever. And actually, at that point in time, he probably didn't need to be found intentionally homeless. He probably needed some extra support,
He's
and
probably struggling.
yeah. I mean, he seemed like definitely struggling. And it just seems like, again, I think we're separating two things here. So I think one sense, the law is the law. So that doesn't necessarily take his well-being into account in the situation. That's not the question really. But as a kind of a housing sector, like, just felt like maybe he had some really good points to make and he wasn't being heard. And you sometimes see kind of people just kind of act in a self-destructive way, which seems to be, as I say, there's kind of some details left out there. But I think that's that kind of the implication I got was that that's what was happening. When actually, that's not really saved anyone any more money in the long run. That's not saved the council more money in the long run. He's presumably going to not disappear off the face of the earth. He's going to be approaching other services. I mean, my guess is he can make a fresh application as a single person now, and maybe he'll be found intentionally homeless. Well, I guess he will, because this is kind of the question. But there's still some stuff that the council will have to do.
I had a couple of questions out of that one, which the first one was different. It's about refusing offers of accommodation and the timing of when you do it in terms of the duty that you're under. Because in this case, and one thing I always find it a bit confusing as to the difference between saying we've discharged our duties towards you because you've refused an offer, which unreasonably refused a suitable offer, and also you've made yourself intentionally homeless, and whether those are two different decisions, or whether they're the same decision. Now, because I've got a case where somebody had they refused an offer of accommodation. The council said, "Okay, we're discharging our duties to you," but they didn't find her intentionally homeless, and that meant she couldn't access the. I have to mention it at least once every session. The Section 190 duties to families who are in priority need but are intentionally homeless, whereas Mr. Beach here would be able to rely on Section or apply for Section 190 assistance because he had been found to be intentionally homeless. So my question is, am I missing this? That if you, when is it that a council can or should say yes, you're intentionally homeless, or just sorry, game over, we've discharged our duties to you?
I can't quote the bit in the law which supports this, but I've certainly had cases where someone is in temporary accommodation under Section 193 and then loses it, and it's basically the duty's discharged, but then it's completely possible to make a fresh application immediately afterwards, same day really, and kind of run it through again. So I actually wasn't kind of looking, I actually wasn't paying attention to that within the case when I read it. I was trying to look at the kind of the other bits. So So I'm just trying to work out. I mean, there is a lot of mention. I'm just looking for it now. There is a lot of mention of becoming homeless intentionally.
Yeah.
But I don't know if I've missed maybe a section that he did reapply. I don't know.
Well, they could. I mean,
yeah.
you can see the bit that I got to. They do say, well, you know, here's the ingredients of intentional homelessness, and this fits in that there was a hotel room offered. It had the offer said that if you don't occupy it, then it'll be cancelled. You didn't occupy it; it was cancelled. You ceased to occupy or have accommodation available to you. But I'll come back. I'll study it in more detail and come back on that. And the other thing I was wondering was whether they could have gone further and said, or if he reapplied, or they may say it if he asks for 190 assistance, is to say, well, you're not in priority need anymore because we granted you priority need on the basis that you were expected to have your children live with you. At them, as at, I haven't figured out exactly which points, but certainly his children weren't living with him when he went to the hotel, or strangely, he had one of the children who wasn't subject to the court order came with him, but
so that I think there's some doubt about that, but there
Yeah.
was. But I mean, the kind of wording suggested the social worker was only saying this was a temporary arrangement, that
Yeah.
and essentially the housing team were looking to find accommodation again that would be able to, you know, kind of would take the dad and the two kids that that were involved. Yeah, again, there's a bit of kind of my memory's not great in terms of whether there's 2 or 3 kids at different times. I mean, I think that it'd be really good to pursue that question, Will,
Yeah.
because it's a really
And
important one a lot of the time.
if you notice, one of the cases that was mentioned here was one I mentioned, I think, in our last session. It was a case called Awua, and yeah, there it is. It's mentioned there, and what I'm going to try and do is read this in more detail, and maybe we can discuss it next time as well, because a lot of these cases, I mean, there's so much work gone into the actual preparation of the legal arguments by the barristers, and then so much consideration by what, you know, if this is the Court of Appeal, which it is, isn't it? Yeah, I mean, these are first-class legal minds applying themselves to these issues, and it's worth sort of spending time analysing what they come up with. But that
what's the chance of getting Toby Van Hagen on your stream, Will? Because I mean,
well,
you know him, don't
I
you?
do know him, yeah. And he's not. He wasn't that keen to come on, I'm afraid. I don't think he particularly wants to discuss these. I think he has enough on his plate dealing with these things in court. But there are other people who would like to come on. Who, I mean, Nick Nicol, who you mentioned before, expressed interest in doing so. So yeah, and other people. And hopefully, as we get more accomplished and more people are aware of us, it might be less of a case of people thinking we're just sort of weirdos talking about Dungeons and Dragons or something, and it might encourage people to come forward. Not that Dungeons and Dragons is for weirdos, but you know what I mean. So I think that's all of the talking points I had in mind. And if anyone wants to, like I say, if anyone wants to read further about it, let me see, I think I get back to it that way. You can go to this link. I'm going to try and do this every week so that there's, and I put a link on the video itself, so you don't have to think what was he on about there. And I'll try and add more as time goes by. One thing I forgot to mention, just a plug for, is the housing rights quarterly newsletter came out. I'm not going to go through it now. This is housing rights is a really useful resource, and they're a very fine bunch of people. I think over time they've become much more involved in the housing rights of migrants, and so they focus on that particularly tough area and complex area. One of the things they're looking at, which I'm going to study a bit more, is asylum accommodation and local connection. And if anyone wants to read a piece of Orwellian writing, there's a government, I bet nobody knew about it, but the government has recently completed a review of the hostile environment and its impact. And there's a link to it here. I think it's over here. Yeah, here we go. But it's Orwellian. When I say Orwellian, it's like 1984. It's like tyranny, and there's something about the Home Office which is Orwellian. It's a huge, very powerful institution, and I think Orwell said that his vision of the future was a boot stamping on a human face for eternity. And the Home Office is quite the sort of place where that could that could happen. But look at this. This is an example of another example of Orwellianism. Is instead of calling it hostile environment, they've new speakers come in and they've called it compliant environment. Because although I think David Cameron and his friends coined the term hostile environment because they had a special committee that met every week, or it was on the agenda every week to see how they could make the environment more hostile for illegal migrants. But they don't want to use that term, so compliant environment. And if you read through it, there's no mention of no recourse to public funds, which is one of the most sinister aspects of it, where people and the hideously high fees that people have to pay to apply for leave to remain, whilst denied the ability to work or claim benefits. But the housing, the people at Housing Rights, Chartered Institute of Housing, are there fighting against this sort of thing, and it's worth reading. I try to keep up with it all because it's complicated because it overlaps with immigration. So that is the last thing I wanted to mention. Just a couple of comments. Let me see. I've got Cheeseface. Let's see if I can just make the comments work just to check it. So this isn't exactly a detailed comment, but evening to you, Cheeseface. Good to see you there. And Cheeseface has made a comment. I should just explain Cheeseface's comment here because we Cheeseface knows that I got a letter this week. I think you two know about it. I mentioned it. This isn't. I got a minded to letter for a Section 184 notice, which was saying I'm minded to find you intentionally homeless, and it really was 88 pages long, and they wanted my comments on this within a week, I think. And I said I may regret this, but I said no, I'm not going to get into a debate about this document. I'm going to just ask you to complete issue a decision, and I'll request a review, and hopefully the reviewing officer and I can try and figure out what's going on. So yeah, 88 pages, that's ridiculous. I'm sorry to the housing officer if you're watching this or hear about it, but I do think maybe 8 pages would be a long letter in this context. But 88 is the longest I've never had a decision letter or a minded to letter more than about 20 pages. So congratulations on that one. And I think Cheeseface, you're the only person that's put comments on, so thank you very much. And I think that's everything for tonight, unless anyone else wants to talk about anything else. Did you guys think it was a useful way of structuring things to have?
I think it's good to kind of go into these cases in more detail.
Yeah.
Kind of, yeah, I think it's a good way. I mean, I'm sure it's it's a bit more niche information for people, but I think it's just a good way to kind of open up this thing because these cases, you know, every week there's kind of new cases happening that will kind of argue about one point or other, and actually they do make a difference overall, even if it might kind of be a very bit of niche situation. So I think it's a good one.
Great. Well, hopefully we can carry on with that. So we're all going to be meeting up again on Thursday on Mike's show, yeah? Okay, so I'm going to finish the show now. And bye, everyone. Hopefully I'll be back again next week. I have had a very bad record of putting out shows, and I'll hopefully get things back to normal and be every Monday from now on. This week's Tuesday because Mike was away yesterday, so couldn't take part. So I thought it was worth putting it back. So bye for now.